Cryptocurrency has become a very hot topic in the financial world in the last few years. While some cryptocurrencies offer solid investment opportunities or valuable functionality, others have been outright scams seeking to cash in on the hype. Regulators are grappling with how to deal with cryptocurrencies, and particularly how to protect investors within this existing legal framework. The biggest legal consideration for participants in this sector in the United States is whether a particular token qualifies as a security. If a token qualifies as a security, it is subject to a number of regulations enforced by the Securities and Exchange Commission, the SEC. Now, the SEC has thus far taken an approach that distinguishes between established tokens that offer users functionality on an existing network and tokens that are sold to finance ventures or even that offer future functionality. Now, for example, the SEC has said that two of the largest cryptocurrencies, Bitcoin and Ethereum, are not securities, but a pure medium of exchange. On the other hand, many businesses use initial coin offerings or ICOs to raise venture funds, and the SEC has given strong indication that these tokens likely are securities. The distinction hinges on the application of what's known as the Howey test from a case decided in 1946. Under the Securities Exchange Act, a security is defined to include an investment contract, which is in turn defined as a contract, transaction, or scheme whereby a person invests money in a common enterprise and is led to expect profits predominantly from the efforts of the promoter or a third party. At present, the SEC has a very fact-specific analysis that is used on a case-by-case basis. They consider the degree of the promoter's ongoing involvement of control, the expectations and motivations of investors when purchasing the tokens, the independent utility or functionality of the token offered for sale, and the breadth and method of the token's distribution, among other factors. But the SEC and the courts that have looked at this have emphasized substance over form, meaning that despite how a token is labeled, if it is marketed as an investment, if it looks like an investment, it will probably be treated as such. If, however, the token's value comes from the functionality or utility, and crucially, that utility is not dependent on the promotional or managerial efforts of a third party, then it probably doesn't qualify as a security. For example, a token that users can purchase to access data storage, for example, is the value is derived from what you can use it for, not its potential as an investment. Unfortunately, the SEC's differentiation doesn't exactly draw a clear line between what is and what isn't a security, and that can be a problem for businesses looking to issue tokens, as well as investors and consumers looking to purchase them. Now, the sheer growth of cryptocurrency means that it's entirely possible, if not likely, that a more clearly defined legal regime will be developed to properly regulate this new asset class. Until then, however, participants in the crypto sphere will need to carefully analyze the applicability of securities law to every product or transaction to ensure it complies with U.S. securities law. A securities lawyer who understands this shifting legal landscape can greatly help businesses and individuals navigate this terrain and avoid securities law violations.